What does that look like? So in one of the cases that I reviewed, there was an attorney whose client had accused police of SA during a traffic stop. When the DNA was conducted on her clothing and on her, they found no evidence. But the attorney was more diligent than that. The attorney actually went a little step further. So his client was being charged with making a false statement and was looking at jail time. And so her attorney did a more thorough search and found that there was DNA evidence there. And that DNA evidence was on the clothing of the police officer in his underwear. So he was able to get the state to drop the charges and they settled out of court. The woman never told the police that she had been penetrated during her assault by the officer, and the evidence was always there, but a diligent attorney is what made the difference. That's what was that's how they were able to get a fair result. So knowing what's going on in your case requires that you view all the evidence and even confront witnesses against you. Again, you can do this before trial. So how does one do that? Well, everyone is entitled to what is called a preliminary hearing. You can confront witnesses against you at the preliminary hearing. What is a preliminary hearing? It is a hearing where you can establish your innocence. You have the right to call witnesses. You have the right to confront witnesses. You have the right to present evidence. In the state of Georgia, it's called a court of inquiry, and it's under Georgia Code subsection 17-7-28, 2020. So the court of inquiry is where, I'll read it for you. The court of inquiry shall hear all legal evidence submitted by either party. If the accused wishes to testify and announces in open court before the court of inquiry his or her intention to do so, the accused may testify in his or her own behalf. If the accused elects to testify, he or she will be sworn in as any other witness and may be examined and cross-examined as any other witness. The rules of evidence shall apply, except hearsay shall be admissible. So this particular hearing is something that you are entitled to receive within 14 days of your arrest and within 21 days of your arrest if you are released on bond. I want to repeat that. This hearing is one that you're entitled to receive within 14 days of your arrest or within 21 days of your arrest if you haven't waived it, if you haven't been released on bond, or if you're released on bond but you still want to have this hearing. Most people have never heard of this hearing, and that's because the state knows how powerful this event is in a criminal case. This is what the U.S. Code says about a preliminary hearing at 18 U.S.C. subsection 3060. Except as otherwise provided by this section, a preliminary examination shall be held within the time set by the judge or magistrate judge pursuant to subsection B of this section to determine whether there is probable cause to believe that an offense has been committed and that the arrested person has committed it.